Hello, everybody. This is Maurice Kempner. I am an attorney, real estate broker, business consultant, and coach. So, today I want to talk to you about why it's probably a big mistake if you don't do your own estate plan. The main reason why is because our government has all these things in play when people need to do things that they don't do. So, one of those things is estate planning. There has to be some kind of plan about what to do with your property when you die. Somebody has to decide, there has to be some kind of system set up. So, if you don't do it yourself, the government will do it for you. It's called intestacy. And so, you probably don't want them to decide these things for you, right? So, that's the number one reason why you would do this, in my opinion. And I think you can figure out all the potential problems that might go on there if you allowed them to solve this problem. When it comes to doing these estate plans, it kind of comes in several parts. One is where all the data gets collected and input into the estate plan, right? The next is the transaction where the estate plan is actually created and given to the client. Now, that's where most practitioners, in my experience, end. In fact, a lot of them just do very simple plans. They might just do a simple will or a simple trust. A lot of times they do this through employers and unions and things like that. And you don't even really get to talk to a real attorney. And they just produce these documents over and over and over in a minimum form. And a lot of them aren't really that good. This is what bar associations call, for example, a trust mill. This is an example of a trust mill where they just spin out these trusts. A good estate plan will have several elements in it, and I'll talk about that a little later. But you really need to have some kind of a discussion in a lot of cases. I'm not saying in every case, depends on how the complexity of your estate. But I think many people miss out on this. Like, it's a good idea to talk to somebody that knows what they're doing about what are some good ideas to do with this. How do you preserve multi-generational wealth once this property is transferred? How do you prepare your heirs to receive that? And what's the purpose of this estate that you're giving to them? What purpose do you want it to serve to them? Most of the time when these transactions are done, there's a division of the property in the transaction, who's going to get what. Then there's a distribution when the last person dies, or whoever in the estate belongs to, when they die, then it all gets distributed. And then the heirs just go out and spend it or do whatever they do with it. So, and that's the end of it. I think a better way in a lot of cases, you have to evaluate this yourself, is you divide it all. Of course, you distribute it upon death. But before all of that happens, you want to have a conversation with your family, and you may need be advisable, helpful to have somebody that's a professional in this area that understands this and does this, provides this kind of service, that can talk to you about preparing your heirs to receive this. Well, I mean, do you want them just to get this money and then just go spend it on bills or put in a new pool or whatever? Is that what you want, or do you want them to? Do you want to try to create some multi generational wealth, generate some cash flow that they can enjoy from then on, month after month? After you're gone, money keeps coming in. I mean, what is it you want to do? So you want to talk to people about that. You want to have some kind of a plan. I think that's the consulting end of it. That's the planning part. So to me, it's much more than a transaction if you want a really good plan. And I think you can see what I'm talking about here. Otherwise, it just gets given to people and they just take it all and spend it. And that's the end of it. So now let's talk about the difference between a will and a trust, right? So in our system, we have these different courts, and these different courts have different jurisdictions. So a criminal court has jurisdiction over whether somebody's guilty or innocent. They render verdicts of guilt or innocence on a criminal charge, usually brought by some kind of a district attorney or prosecutor. And that's the only jurisdiction they have. Civil courts, they do verdicts on civil disputes between companies or people. Family law does family law. Verdicts on division of marital property, custody, things like that. Probate court has jurisdiction over the assets and property of someone who's died, right? Because some dead people can't own property; they can't own it. So the probate court has a jurisdiction. They put on a trial, and they have basically that's what it is. You can call it whatever you want, but that's what it is. So it's like a trial. And at the end of this trial, they render verdicts of ownership. That's what they do. That's their mission. That's who they are. Okay. Now, in this trial, somebody who is like an executor of the will, they're like a witness. They help the court move things along. They say what it is that people who've died wanted, that kind of thing. They're kind of a facilitator witness. And the will itself, that's like a gun or fingerprints, for example, in a criminal trial. It's evidence that helps the court decide what their verdict should be. That's a will. A trust is just a make believe entity, just like a corporation or even a country is make believe, right? They're just legal entities that are made up by people, and then they believe they're true or they exist, and everybody agrees they do, right? So the laws come up with this idea of a trust. And so then what happens when you do a trust is the trust owns your property. You put your house in the trust, you put bank accounts and other things in the trust. There's certain things you want to put in and certain things you don't, right? So you put all these things in the trust, and the trust owns it. So when you die, the owner didn't die, right? The owner's still alive. The owner's the trust. But the new trustee, who's ever designated to be the new trustee in the trust, they take over and they distribute the assets and handle everything, and they do it outside of probate because the owner hasn't died, and thus the probate court has no jurisdiction over those assets because the owner is the trust and it didn't die. Now, for a good estate plan to work, I think there's several things you need. So you do need wills. We call them pour-over wills. Now, these pour-over wills, what they do is they will everything that you didn't put in the trust, you will to the trust, right? So if it's not in some other kind of trust or whatever, you will it to the trust, right? So this could be like personal items that don't have a title, like clothes and furniture and personal effects and things. They could all go into the trust. And if you want to designate how those things are distributed, you can put all that in the trust, right? You just do a blanket will to send everything to the trust. That's one of it. Then you do a financial power of attorney, which makes it so if you're not dead, but you still need to file tax returns, pay bills, pay mortgage or rent, whatever it is, you've got somebody designated that can do that. Now, a lot of these trust mills, they don't mess around with that. They just want to say some cheap trust, make their dollars and go into the next one. That's an example of what I'm talking about there. So anyway, you have this now, so this can be taken care of if you're incapacitated. Usually it's your spouse if you have one, and then if not, it's somebody else, right? But this is your chance to decide that. Then you do a medical power of attorney, and that's kind of the same thing as financial when it deals with medical. So somebody can talk to your doctor, help make medical decisions and things like that. Then we do a living will, which is basically pull the plug, don't pull the plug kind of thing, so that you don't have family members fighting over your wishes in that regard. That can get really expensive. It's likely not going to be an issue for most people, but it can be, and if it happens, it can be real expensive. And then there's other things you can put in your estate plan, like you don't want the kids to get the money till they're 25, or you can hold it even longer. You can do all kinds of things, and that's part of the consultation that I was talking about earlier that you might want to have with somebody. So anyway, that's the estate plan. That's why I think it's important. I think it's if you have anything, any kind of real estate, a house, rental properties, anything like that, especially, you're going to want to do it. Probate fees can be very expensive. I think in most states they start around 5% of the value of the estate. So let's say the only thing you have in the house or in the estate is a house, and it's worth $100,000. And even if you owed 90,000 on it, the house is worth 100,000. 5% of that is $5,000. That's the probate fee on that house. You see, so it's better just to avoid it and save the money, keep the government and courts out of your business, and take control of what you're going to do with the generation that fills your shoes when you're gone and how you want them to do it. All right. I hope that helps.